Yo. Always check description for more details. Entries in the course of business records rule. 1. This hearsay exception states, SEC. 43. Entries in the course of business. Entries made at, or near the time of the transactions to which they refer, by a person deceased, or unable to testify, who was in a position to know the facts therein stated, may be received as prima facie evidence, if such person made the entries in his professional capacity or in the performance of duty and in the ordinary or regular course of business or duty. 2. The exception is commonly encountered in breach of contract suits and suits for collection of a sum of money. The plaintiff, let us say, is Technics Corporation. The complaint alleges that it delivered 100 television sets to MS Tronics Store, the defendant, and that the latter failed to pay for the sets delivered. Assume that the defendant filed an answer denying the plaintiff's allegations. The plaintiff now wants to introduce a delivery receipt signed by the manager of the defendant acknowledging the receipt of the sets delivered. The plaintiff also wants to introduce the company's accounting records prepared by a clerk who personally knows of the fact of delivery. The witnesses are the delivery man and the clerk, all employees of the plaintiff. The witnesses would be testifying on the basis of their first-hand knowledge of the events that transpired. Since their perception and memory of the events may be tested by cross-examination, our fact situation would not require an exception to the hearsay rule. But if the delivery man and the clerk are now dead and all that the plaintiff has are the delivery receipt and the accounting records showing defendant's debt, the problem starts. This exception allows the presentation of the delivery receipt and accounting records even if the delivery man and the clerk are no longer available to testify. 3. In our version of the exception, the necessity for the admissibility of such evidence arises from the absence of the person who has personal knowledge of the facts. He is absent because he is dead, outside of the jurisdiction of the court or otherwise, unable to testify. 4. Before entries in the course of business could be accepted from the hearsay rule, the concurrence of the following requisites must be shown. A. The person who made the entry must be dead or unable to testify. B. The entries were made at or near the time of the transactions to which they refer. C. The entrant was in a position to know the facts stated in the entries. D. The entries were made in his professional capacity or in the performance of a duty, whether legal, contractual, moral, or religious. And E. The entries were made in the ordinary or regular course of business or duty. Petula v. People, 669 SCRA 135, 171, April 11, 2012. 5. It has been held that entries in the payroll, being entries in the ordinary course of business, enjoy the presumption of regularity under Sec. 43 of Rule 130 of the Rules of Court, Sapio v. Undalock Construction, 554 SCRA 148. 6. The rules on electronic evidence expressly exempt business records from the application of the hearsay rule provided the mechanics of record keeping of such records are shown by the testimony of the custodian or other qualified witnesses. The reliability of business records is, therefore, presumed. See Sec. 1 Rule 8, Rules on Electronic Evidence. The presumption, however, may be overcome by evidence of the untrustworthiness of the source of information or the method or circumstances of the preparation, transmission or storage thereof. Sec. 2 Rule 8, Rules on Electronic Evidence. Declarations against interest. 1. The rule on declaration against interest provides, SEC. 38. Declaration against interest. The declaration made by a person deceased or unable to testify, against the interest of the declarant, if the fact asserted in the declaration was at the time it was made so far contrary to declarant's own interest, that a reasonable man in his position would not have made the declaration unless he believed it to be true, may be received in evidence against himself or his successors in interest and against third persons. 2. This is a well-established exception which finds confirmation in human nature and experience. People normally speak freely and even with untruth when the statement is in their interest, but are usually unwilling to speak falsely against their interest. Wigmore considers a declaration against interest as also founded on necessity on account of the impossibility of obtaining other evidence from the same source, the declarant being unavailable in person to testify on the stand on account of death, absence from the jurisdiction or serious illness. 5 Wigmore on evidence, Sec.1456. 3. This exception refers to a declaration made by a person who, at the time his declaration is presented in evidence, is already dead or unable to testify. This declaration must be one which, when made, was known to the declarant himself to be against his interest, pecuniary or moral, and which would not have been made unless he believed it to be true. It is clear from the rule that it is not enough that a declaration against interest was made. It is necessary that the declarant knew that the statement was against his interest and which he would not have made had it not been true. 4. A statement by the debtor before he died that he owes the creditor a sum of money, or an oral acknowledgment by the principal that he received the money previously entrusted to his agent, are clear declarations against the interest of the person making the statement. 5. This exception will not apply where the declarant is available as a witness. The declarant must be dead or is unable to testify. Death is easy to explain. But what kind of unavailability, aside from death, is a sufficient reason to justify the application of the exception? Being outside the territorial jurisdiction of the country may be a good reason for unavailability if his exact whereabouts abroad are unknown. If known, his deposition may be taken and the exception will not apply. Serious physical or mental impairments may be grounds for considering a person unavailable. 6. The declaration contemplated under Sec. 38 of Rule 130 is a declaration against interest. If the declaration is favorable to the interest of the declarant, it is a mere self-serving statement and does not fall as an exception to the hearsay rule. 7. As a rule, the interest against which the declaration may have been made should be either a pecuniary or moral interest, but, in our jurisdiction, the declaration could possibly be against one's penal interest. Cat 18e. If one admits to a crime, he is also civilly liable, a liability. Chat I8 pecuniary. See for further readings, People v. Toledo, 51 Phil.826. 8. Note that the declaration against interest made by the deceased, or by one unable to testify, is admissible even against the declarant's successors in interest or even against third persons. Sec. 38 Rule 130, Rules of Court. Declaration about pedigree. 1. The exception as provided in Sec. 39 of Rule 130 states, Sec. 39. Act or declaration about pedigree. The act or declaration of a person deceased, or unable to testify, in respect to the pedigree of another person related to him by birth or marriage, may be received in evidence where it occurred before the controversy, and the relationship between the two persons is shown by evidence other than such act or declaration. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when and the places where these facts occurred, and the names of the relatives. It embraces also facts of family history intimately connected with pedigree. 2. To be admissible as an exception to the hearsay rule, it must be shown that a. The declarant is dead, or unable to testify, b. The declarant is related by birth or marriage to the person whose pedigree is in issue, c. The declaration was made before the controversy, and d. The relationship between the two persons is shown by evidence other than such act or declaration. Sec. 39 Rule 130, Rules of Court. 3. The declaration of Jose, already dead, prior to his death and prior to any controversy, that Juan is his illegitimate son, is a declaration about pedigree. Similarly, a statement from a mother while living, that her daughters, Maria and Petra, were sired by the same father is admissible. 4. Be it noted that the declaration about pedigree may be received in evidence if the relationship is shown by evidence other than the declaration. Sec. 39 Rule 130, Rules of Court. 5. The word pedigree includes relationship, family genealogy, birth, marriage, death, the dates when and the places where these facts occurred, and the names of the relatives. It also embraces facts of family history intimately connected with pedigree. Sec. 39 Rule 130, Rules of Court. Family reputation or tradition regarding pedigree. 1. The exception provides, Sec. 40. Family reputation or tradition regarding pedigree. The reputation or tradition existing in a family previous to the controversy, in respect to the pedigree of any one of its members, may be received in evidence if the witness testifying thereon be also a member of the family, either by consanguinity or affinity. Entries in family Bibles or other family books or charts, engraving on rings, family portraits and the like, may be received as evidence of pedigree. 2. This exception involves A statement by a member of the family either by consanguinity or affinity. B. The statement is about the reputation or tradition of the family in respect to the pedigree of any member of the family, and C. The reputation or tradition is one existing previous to the controversy. Sec. 40 Rule 130, Rules of Court. 3. Entries in family Bibles or other family books or charts, engravings on rings, family portraits and the like, be received as evidence of pedigree aside from family tradition or reputation. Sec. 40 Rule 130, Rules of Court. Common reputation. 1. The exception, as quoted, declares, Sec. 41. Common reputation. Common reputation existing previous to the controversy, respecting facts of public or general interest more than 30 years old, or respecting marriage or moral character, may be given in evidence. Monuments and inscriptions in public places may be received as evidence of common reputation. 2. Common reputation is admissible in evidence where the reputation refers to a matter of public or general interest, or respecting marriage or moral character and said matter is more than 30 years old. The common reputation must likewise be one existing prior to the controversy. This common reputation may, on the other hand, be established by monuments and inscriptions. Sec. 41 Rule 130, Rules of Court. 3. Common reputation is hearsay, like any other exception to the hearsay rule, but is admissible because of trustworthiness. Reg. v. Bedfordshire, 4E and B 535, 82 ECL 535, 542. 4. While common reputation in the community may establish a matter of public or general interest, marriage or moral character, it cannot establish pedigree. This is established by reputation in the family and not in the community. See Sex.40 and 41 Rule 130, Rules of Court. Entries in official records. 1. The exception, as stated, follows, Sec. 44. Entries in official records. Entries in official records made in the performance of his duty by a public officer of the Philippines, or by a person in the performance of a duty specially enjoined by law, are prima facie evidence of the facts therein stated. 2. The requisites for the admissibility in evidence of entries in official records, as an exception to the hearsay rule, are: A. The entry was made by a public officer or by another person specially enjoined by law to do so. B. It was made by the public officer, or by such other person in the performance of a duty specially enjoined by law, and C. The public officer or other person had sufficient knowledge of the facts by him or her stated, which must have been acquired by the public officer or other person personally or through official information. Sabili v. Commission on Elections, 670 SCRA 664, 670, April 24, 2012. 3. In a case, petitioner denies receiving the assessment notice sent by respondent Beer. The respondent presented the Beer record book where the name of the taxpayer, the kind of tax assessed, the registry receipt number and the date of mailing were noted. The Beer records custodian also testified that she made the entries therein. Respondent offered the entry in the Beer record book and the testimony of its record custodian as entries in official records in accordance with Sec. 44, Rule 130 of the Rules of Court. In this case, it was not stated in the transcript of stenographic notes how and from whom the witness obtained the pertinent information. Moreover, the witness did not attest to the fact that the report was acquired from persons under a legal duty to submit the same. Hence, Sec. 44 of Rule 130 finds no application in the present case. The evidence offered by respondent does not qualify as an exception to the rule against hearsay evidence. Barcellin Roxas Security, Inc. v. Commissioner of Internal Revenue, 498 SCRA 126. Commercial lists and the like. 1. The exception declares, Sec. 45. Commercial lists and the like. Evidence of statements of matters of interest to persons engaged in an occupation contained in a list, register, periodical, or other published compilation is admissible as tending to prove the truth of any relevant matter so stated if that compilation is published for use by persons engaged in that occupation and is generally used and relied upon by them therein. 2. Certain commercial lists and reports of matters of interest to persons engaged in a particular occupation are admissible in evidence as exceptions to the hearsay rule, provided they are made by persons engaged in that occupation and are generally used and relied upon by them, and those lists and reports are published. Sec. 45 Rule 130, Rules of Court. Learned treatises. 1. This self-explanatory and common exception states, SEC. 46. Learned treatises. A published treatise, periodical or pamphlet on a subject of history, law, science, or art is admissible as tending to prove the truth of a matter stated therein if the court takes judicial notice, or a witness expert in the subject testifies, that the writer of the statement in the treatise, periodical or pamphlet is recognized in his profession or calling as expert in the subject. 2. History books and published findings of scientists fall within this exception provided that an expert on the subject testifies to the expertise of the writer or the court takes judicial notice of such fact. Testimony or deposition at a former proceeding. 1. The exception provides, SEC. 47. Testimony or deposition at a former proceeding. The testimony or deposition of a witness deceased or unable to testify, given in a former case or proceeding, judicial or administrative, involving the same parties and subject matter, may be given in evidence against the adverse party who had the opportunity to cross-examine him. 2. The testimony contemplated as one given in a former case or proceeding, judicial or administrative, involving the same parties and subject matter. The testimony is given by one who is now deceased or unable to testify. Said testimony may be given in evidence against the adverse party provided the latter had the opportunity to cross-examine the witness who gave the previous testimony. Sec. 47 Rule 130, Rules of Court. 3. For Sec. 47 of Rule 130 to apply, the following requisites must be satisfied. A. The witness is dead or unable to testify. B. His testimony or deposition was given in a former case or proceeding, judicial or administrative, between the same parties or those representing the same interests. C. The former case involved the same subject as that in the present case, although on different causes of action. D. The issue testified to by the witness in the former trial is the same issue involved in the present case. And E. The adverse party had an opportunity to cross-examine the witness in the former case. Manlichlik v. Kalaunen, 512 SCRA 642. Exception to the hearsay rule in child abuse cases. 1. Under Sec. 28 of the Rule on Examination of a Child Witness, a hearsay statement of a child which under the rules of court, is not admissible for being hearsay because the facts testified to are not within his personal knowledge, may be admitted in evidence in any criminal or non-criminal proceeding. 2. The testimony is admissible provided the same be offered in child abuse cases and the statement made by the child is one describing any act or attempted act of child abuse. Aside from above requirements, the following must likewise be complied with. A. The proponent shall make known to the adverse party the intention to book and its particulars to provide him a fair opportunity to object before the hearsay statement may be admitted. B. If the child is available, the court 8 Hall, upon motion of the adverse party, require the child to be present at the presentation of the hearsay statement for cross-examination by the adverse party, and C. When the child is unavailable, as when the child is deceased, suffers from physical infirmity, mental illness, loss of memory, or because the child will be exposed to severe psychological injury, the fact of such circumstance must be proved by the proponent and the hearsay testimony shall be admitted only if corroborated by other admissible evidence. Sec. 28 A. Rule on Examination of a Child Witness. 3. In ruling on the admissibility of the hearsay statement, the court shall consider the a. time, b. content, and c. circumstances surrounding the making of the statement which would provide sufficient indicia of reliability. Sec. 28b. Rule on Examination of a Child Witness. Certain factors are also to be considered by the court before deciding to admit the statement, like the motive to lie, the general character of the declarant child, the number of persons who heard the statement, the spontaneity of the making of the statement, the timing of the making of the statement, the relationship between the declarant child and the witness, the remoteness of the possibility of a faulty recollection and other circumstances surrounding the statement. Sec. 281b. Rule on Examination of a Child Witness. C. Opinion evidence. The rules on opinion evidence provide, SEC. 48. General Rule. The opinion of a witness is not admissible, except as indicated in the following sections. SEC. 49. Opinion of expert witness. The opinion of a witness on a matter requiring special knowledge, skill, experience or training which he is shown to possess, may be received in evidence. SEC. 50. Opinion of ordinary witnesses. The opinion of a witness for which proper basis is given, may be received in evidence regarding a. The identity of a person about whom he has adequate knowledge, b. a handwriting with which he has sufficient familiarity, and c. the mental sanity of a person with whom he is sufficiently acquainted. The witness may also testify on his impressions of the emotion, behavior, condition or appearance of a person. Admissibility of opinion evidence, Bar 2011. As a rule, the opinion of a witness is inadmissible, Sec. 48 Rule 130, Rules of Court. This is because when a witness testifies, a witness does so only with respect to facts personally observed by him, and it is for the court to draw conclusions from the facts testified to. When opinion evidence is admissible, expert testimony, Bar 2011. 1. When the opinion is that of an expert, i.e., the opinion of a witness requiring special knowledge, skill, experience or training which he is shown to possess, it may be received in evidence, Sec. 49 Rule 130, Rules of Court. 2. The court is not, however, bound by the opinion of an expert such as a handwriting expert. Expert opinion evidence is to be considered or weighed by the court, like any other testimony, in the light of its own general knowledge and experience upon the subject of inquiry. The probative force of the testimony of an expert does not lie in a mere statement of his theory or opinion, but rather in the aid that he can render to the courts in showing the facts which serve as a basis for his criterion and the reasons upon which the logic of his conclusion is founded. Dizon v. Tuazon, 557 SCRA 487. Expert opinions are not ordinarily conclusive. When faced with conflicting expert opinions, courts give weight and credence to that which is more complete, thorough and scientific. Bacalso v. Patigos, 552 SCRA 185. 3. For instance, in examining forged documents, the testimonies of handwriting experts are conceitedly useful. However, resort to these experts is not mandatory or indispensable because a finding of forgery does not depend entirely on their testimonies. Judges must also exercise independent judgment in determining the authenticity or genuineness of the signature in question, and not rely merely on the testimonies of handwriting experts. Mendez v. Court of Appeals, 672 SCRA 200, 209, June 13, 2012. A handwriting expert is not indispensable to prove that a signature was indeed a forgery. The opinion of handwriting experts are not necessarily binding upon the court, the expert's function being to place before the court data upon which the court can form its own opinion. While these experts are helpful in the examination of forged documents because of the technical procedure involved in analyzing them, resort to them is not mandatory or indispensable to the examination or comparison of handwriting. Lorzano v. Tabayag, 665 SCRA 38, 47, February 6, 2012. Opinion of an ordinary witness, when admissible, Bar 2005. 1. When the opinion is that of a witness who is not an expert, ordinary witness, his testimony may be admitted in evidence provided that the proper basis of the opinion is given and the subject of the opinion is any of the following matters. A. The identity of a person about whom the witness has adequate knowledge, b. the handwriting of a person with which the witness has sufficient familiarity, c. the mental sanity of a person with whom he is sufficiently acquainted, and d. the impressions of the witness of the emotion, behavior, condition or appearance of a person. Sec. 50 Rule 130, Rules of Court. 2. In any of the above, the opinion of an ordinary witness is admissible. D. Character evidence. Inadmissibility of character evidence. 1. Character is the aggregate of the moral qualities which belong to and distinguish an individual person, the general results of one's distinguishing attributes. It refers to what a man is and depends on the attributes he possesses. It is not the same as a man's reputation because the latter depends on attributes which others believe one to possess. Character signifies reality while reputation signifies what is accepted to be reality at present. Black's Law Dictionary, 5th ed., p. 211. In other words, while character is what the person really is, reputation is what he is supposed to be in accordance with what people say he is, and is dependent on how people perceive him to be. 2. Character evidence is, as a rule, not admissible. Sec. 51 Rule 130, Rules of Court. Character is generally irrelevant in determining a controversy because the evidence of a person's character or trait is not admissible to prove that a person acted in conformity with such character or trait in a particular occasion. 29 Amur 2d Evidence, Section 363. The rule is that the character or reputation of a party is regarded as legally irrelevant in determining a controversy, so that evidence relating thereto is not admissible. Ordinarily, if the issues in the case were allowed to be influenced by evidence of the character or reputation of the parties, the trial would be apt to have the aspects of a popularity contest rather than a factual inquiry into the merits of the case. After all, the business of the court is to try the case, and not the man, and a very bad man may have a righteous cause. People v. Lee, 382 SCRA 596. Evidence of bad moral character of the accused, Bar 2010. 1. In a criminal case, the prosecution cannot prove the bad moral character of the accused in its 8 evidence in chief. It can only do so in rebuttal, Sec. 51, Ag. 2, Rule 130, Rules of Court. This means that the prosecution may not offer evidence of the character of the accused unless the accused himself has offered evidence of his good moral character. The prosecution, therefore, must wait until the accused puts his character in issue during the proceedings. Where the accused proves his good moral character pertinent to the moral trait involved in the offense charged, Sec. Rule 130, Rules of Court, he opens the door to the prosecution to prove that his moral character is, in fact, bad. Then and only then may the prosecution prove the bad moral character of the accused. The relevant provision provides, SEC. 51. Character evidence not generally admissible, exceptions. A. In criminal cases, 1xxx 2, unless in rebuttal, the prosecution may not prove his bad moral character which is pertinent to the moral trait involved in the offense charged, italics supplied. 2. As mentioned, the prosecution is forbidden by Sec. 51 Ag. 2 of Rule 130 to initiate evidence of the bad moral character of the accused. It prevents the government from opening the doors towards the introduction of character evidence of the accused. The rule that confines the right of the prosecution to prove the bad moral character of the accused only by way of rebuttal is a logical one. It prevents a pronouncement of guilt on account of his being a bad man and instead anchors a conviction on the basis of the sufficiency of evidence of his guilt. The rule also prevents the inference that, being a bad person, the accused is more likely to commit a crime. The rule likewise discourages the presentation of the so-called propensity evidence, i.e., evidence that one acts in accordance with one's character. 3. The offering of evidence of good moral character is a privilege of the accused and the prosecution cannot even comment on his failure to produce such evidence. But once he raises the issue of his good character, the prosecution may, in rebuttal, offer evidence of the defendant's bad character. People v. Lee, 382 SCRA 596. Evidence of good moral character of the accused, Bar 2010, 2011. 1. The accused may prove his good moral character when pertinent to the moral trait involved in the offense charged, Sec. Rule 130, Rules of Court. The applicable provision states, SEC. 51. Character evidence not generally admissible, exceptions. XXXA. In criminal cases, 1. The accused may prove his good moral character which is pertinent to the moral trait involved in the offense charged. 2. While the prosecution is forbidden to present evidence of the bad moral character of the accused unless in rebuttal, the general rule against propensity evidence does not apply to the accused who is allowed to offer evidence of his good character. Not all aspects, however, of the character of the accused may be proven. Only those moral traits involved in the offense charged are provable. In doing so, an accused may advance more than one character trait as evidence so long as each trait is germane to some issue in the case. This theory is plain from a reading of Sec. 51 of Rule 130. 3. The accused may prove his good moral character which is pertinent to the moral trait involved in the offense charged. When the accused presents proof of his good moral character, this strengthens the presumption of innocence and, where good character and reputation are established, an inference arises that the accused did not commit the crime charged. This view proceeds from the theory that a person of good character and high reputation is not likely to have committed the act charged against him. In contrast, the prosecution may not prove the bad moral character of the accused except only in rebuttal and when such evidence is pertinent to the moral trait involved in the offense charged. This is intended to avoid unfair prejudice to the accused who might otherwise be convicted not because he is guilty but because he is a person of bad character. The offering of character evidence on his behalf is a privilege of the accused, and the prosecution cannot comment on the failure of the accused to produce such evidence. Once the accused raises the issue of his good character, the prosecution may, in rebuttal, offer evidence of his bad character. People v. Lee, 382 SCRA 596. Evidence of character of the offended party. 1. The good or bad moral character of the offended party may be proved by the accused if it tends to establish in any reasonable degree the probability or improbability of the offense charged. Sec. Rule 130, Rules of Court. Sec. 51 (3) of Rule 130 provides, Sec. 51. XXXA. In criminal cases, 3. The good or bad moral character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the offense charged. 2. It will be readily observed that the above provision pertains only to criminal cases. Also, not every good or bad moral character of the offended party may be proved under this provision, but only those which would establish the probability or improbability of the offense charged. This means that the character evidence must be limited to the traits and characteristics involved in the type of offense charged. In one rape case, where it was established that the alleged victim was morally loose and apparently uncaring about her chastity, the court found the conviction of the accused doubtful. Civil Service Commission v. Belligan, 440 SCRA 578. Sexual Abuse Shield Rule in child sexual abuse cases. The following evidence, however, is not admissible in any criminal proceeding involving alleged child sexual abuse under the Sexual Abuse Shield Rule. A. Evidence to prove that the alleged victim engaged in other sexual behavior, and b. Evidence offered to prove the sexual predisposition of the alleged victim. See Sec. 30, Rule on Examination of a Child Witness, A.M. No. 00407 SC. Under this rule, the accused is not allowed to prove the bad moral character of the offended party. However, evidence of any of the above is admissible to prove that a person other than the accused was the source of semen, injury or other physical evidence. Character evidence in civil cases. In civil cases, evidence of the moral character of a party is admissible only when pertinent to the issue of character involved in the case. Sec. 511b, Rule 130, Rules of Court. Thus, evidence of a party's intemperance may be admitted when such is pertinent to the issues involved. Evidence of good character of a witness. Evidence of the good character of a witness is not admissible until such character has been impeached. Sec. 14, Rule 132 and Sec. 51, c. Rule 130, Rules of Court. It is error for counsel to offer evidence of the good character of his witness who is presented in court for the first time, since he could not have been previously impeached. End of Chapter 6. Please share. Thank you.